Okay, we're back again, and I still have the supply card that has been called a bread card by some idiot out there, but that's to keep all the papers sort of together because I have several papers to show. I am not saying this is what happened because I say so. I want to show, like I did on the medical side of the lawsuit for Therese Westphal and the case against LASE MED INC, which by the way is matter of public record, so I can discuss it. Nobody's trying to really discuss it. They are trying to push it under the table and saying, oh, there is a court case and she lost. Actually, instead of saying she was, the decision was for the plaintiff, they say, of course, to their convenience, she was found guilty as if it were a criminal trial. But anyway, so that's another ridiculous thing. But what I want to present is the legal part and what all of this started. And whenever they filed it in Arkansas, I think it was somewhere in February, we had already left and we had already been operating in Oklahoma, but I did not receive it. I was not served until much later. I don't remember if it was the end of March or somewhere in April. I don't remember the exact date. Everything has happened. So many events, it's ridiculous. The whole thing is ridiculous. And in this filing of the case, it was against LASE MED INC, and LASE MED INC is a Nevada corporation. This says that LASE MED INC is a Nevada corporation, but here it is, it says was doing, and then will be enlarged, but I'm showing here, it says was doing business in Arkansas. No, LASE MED INC is a Nevada corporation, is a holding corporation, research and development, and contracted LASE MED INC of Arkansas to offer the treatment. So they're two total different entities. And since LASE MED INC, the Nevada corporation, never did business in Arkansas, they could not legally have included it in this document. They included it by line. And it is a lie because they could have looked at the records of LASE MED INC of Arkansas and find out what kind of corporation it was. Was it a totally separate corporation? Actually, it was an S corporation, a totally different setting than the Nevada corporation. So that was the first lie. Then, of course, they go on and give the defendant's side of the story about what happened and her story about what she was told about the treatment. And on this page, I marked it. And you see what they're saying? That's just they don't understand anything. They are saying in the statement that I claim with the patient that the cancer cell are killed because they are exposed to extreme heat. Now, if they were exposed to extreme heat, like all of our patients know, they would have burns on the skin. And it would have collateral damage, it would affect everything, and you would see nothing appears on the outside. And that's the reason why they can attack us or nothing happened, you did nothing. Now instead they're saying you're using extreme heat. No. That's a lie, and that's not at all what we are saying in our website. That's another lie, either by ignorance or convenience, whatever it is. And then she said that she was having problem, and the problem, like I explained in the medical side before, were because of what she didn't follow our guideline, and she had minor problems. They were just discomfort caused by not doing what we told her to do. But in this document again, at the bottom she said that she called me, she wanted to know what was going on, and we never answered her call, which is another lie because all the patients out there know perfectly well. They keep calling me all the time. And I have evidence that I presented to the court that she actually came back for a second ultrasound. So that's an absolute lie, again. And then, the really big part of this document filed in federal court in the Eastern District of Arkansas after I had left and I was no longer under that jurisdiction. There it is. It said that application of the alleged treatment. Now they're even saying it's not a treatment. I did something, but it wasn't a treatment. To the plaintiff, cancer was not called for, but any appropriate medical regimen. any appropriate who decided what's appropriate? The AMA. Well, that if you want to go through standard treatment. If you don't, then all of that falls. But notice what it says at the bottom. Okay, the breast cancer treatment that she received does not fall within any recognized standard of care. Yes, we know that, and she knew it too. It was not standard care, and she was looking for something different. I explained to you in the first part when we were talking about what she did and what happened. She had two opinions before she went for something else. And see here, expert testimony is not needed to debunk this junk science. And that's what was important, because he later denied, even though this is on record, the attorney for the plaintiff, the recycled politician, denied that he had a college junk science. And as you know, you can go on our website, the one that says, the main LASE MED INC website, lasemedinc.com, and you can click on the section copycats, and you can find all the universities that are receiving money for research, and they are doing a large amount of research on this junk science. And Stanford said that held very promising, a very promising future. They stopped doing it for breast cancer. They are doing it for other things. But also, another thing that they were saying here, and I'm trying to find, here it says, violation of the Arkansas Deceptive Trade Practices Act. Okay, Arkansas Deceptive Trade Practices. And that explain, here it explains what a deceptive trades practices are, and none of those. It just involve the people that are selling. You can view it. Selling product, not medical services. But here it says that is the Attorney General. People can complain to the Attorney General, and the Attorney General can bring action about a company, not a private lawsuit. It's the Attorney General that can do that, and it brings charges to the company that has violated their laws. And what happened is, as you can read it here, the court may restore any actionable loss, which means you have to repay for whatever the client paid. And then you see, they can impose a penalty. You read that? No, it's underlined. Not exceeding $10,000. And then the other thing is that they can forfeit the franchise, corporate charter, and other license. So basically they can revoke the corporate status of the corporation. Well, by the time they brought this lawsuit, it was no longer LASE MED INC of Arkansas. So the whole thing is a farce. And with this farce, we had to spend a fortune in attorneys, because I intended to represent myself, but they told me because it's a corporation, it's against the corporation, then I could not do it. I had to hire an attorney. And I ended up having to hire 3 different attorneys. And only, as I said, after the third one was hired, I finally was able, 3 years later, to get a copy of the plaintiff medical record before they refused. When I got the copy of the medical records, I realized that she was fine. And even the expert witness of the plaintiff, who is a doctor, get this, is an oncologist, the medical expert, to discuss a treatment that is leading edge and it's different from standard method. The expert witness was an oncologist who had been working in Arkansas for 35 years and had been treating patients with chemoradiation for 35 years. Standard care, nothing else. And this was the expert to discuss an advanced case of photodynamic therapy and a modified and the most advanced method of photodynamic therapy that could be. What kind of expert witness could that be? But in the end, he actually said that after the treatment, she had a PET scan 4 months later, and it was saying that the cancer had expanded and had gotten to be a size of 4 inches by 4 inches, covering most of the breast. And so then she had to have chemo. She had 2 months of chemo. And at the end of that, they couldn't find anything. They couldn't find the cancer. If it actually had been 4 inches, it could not be. I explained that before. It could not be that it disappeared because it was just an inflammation. They could not find it. And the expert witness said she had a remarkable recovery. But then he said, well, then later it came back. No, it didn't. They decided to do surgery anyway. And it was on the record, and I showed all of that before. Well, when we actually got the records, we had proof that she was fine. And we were successful, even though they're lying about what happened. So with the copy of her records and with the picture, one of our former patients that did the deposition, one of the 4, we originally had filed 12 patients that could testify they were fine. And either they were disqualified because of where they lived, the Canadian, okay, but others, it was just nonsense. But we came down to 6. And then my attorney said, no, 3 are enough. And I said, okay, do 4. And so he had the deposition of 4. Actually, I had to stop because it was too expensive. They charged me a ridiculous amount of money for them. About $1,000 a piece, so it's no minor expense. So we got 4, and one of those 4 is sent picture, so of how she healed. It's not a hearsay. How it looked during the healing that might look worse than it was at the beginning, but it healed, and she didn't have any cancer left, and it was obvious from the picture. You can find them on the website under breast cancer. One of them, she really looked bad, and some of the trolls said, oh, that is not a real picture. That looks like you put some Play-Doh there. It's just completely ridiculous, but the pictures are there. So I requested our attorney to submit a request for summary judgment because this case had no bearing, it had no value, was totally frivolous. So I requested summary judgment to try to save money and put an end to this nonsense. Because the court, on top of everything else, never had jurisdiction against us. We were out of the state. The court does not have jurisdiction of somebody, a corporation out of the state, and a person outside the state. The reason why I was still pushing to do something in court, because if it come out, well, we just don't have jurisdiction against it, that would not have satisfied me. I knew that I could prove that what she was saying was a lie. I had all the evidence of all the lies she had said. I had the evidence of what her real condition was. I had the evidence of the patients that are doing okay. I had the evidence of explaining the technology. So I had plenty. That's why I kept going on, even though the court had no jurisdiction over me. So what happened? I asked the attorney to file for a summary judgment. And we did, and nothing happened after we filed for the summary judgment. That's not right. Nothing happened. Then I got a communication that the judge has set a hearing for a settlement out of court. And I thought right there, something was not quite right. I request a summary judgment, and he said that there is a date for a settlement hearing, out of court settlement. Absolutely not. If anything, they should pay me for all the damage they caused me. Not me paying somebody that is lying, an opportunist that is trying to find money anywhere, out of work opportunist that is trying to raise money any way possible, and out of politics, politician that was trying to create a situation where the medical school could come out in La Rock to come out to see, we are doing this great new technology, we are doing this research, we are so great. patting themselves in the back and trying to copy me. So I had this summary judgment request, and I was waiting for an answer. Nothing happened. Nothing happened. Then, one day, we found on the web the troll disclosing something that went on during deposition of Wendy Simmons. She did her deposition on what happened, and since she manages the office and she managed the treatment center, she knew the doctor, she had all the record, the hiring and everything. So what she did was, she was asked and she said, yes, the last doctor we have is a DO and they are not allowing him to work with us anymore. But that's because his shortcoming, he didn't do his job. He was supposed to keep records, which he didn't. And he was caught doing that. That's the only thing they had against him. Beside the fact that DOs in Oklahoma have to be strictly DO. They cannot work in alternative medicine because of their training. They have training. They have limited training, and so the history, in the opinion of medical board in Oklahoma and the state law, is that they really should not work in alternative medicine. On the other hand, in Oklahoma you have the law that you can be an alternative practitioner and you can be treating patient as a healer or a naturopathic doctor. You don't have to have a license. You don't have to register with the state. You can do it as long as you do not claim that you are an MD, which I never did. But that's why the trolls are now saying, oh, she used to say that she was an MD and now she recently removed from the her website, which is an absolute lie. That is a pathetic attempt to show, see, she's still violating the state law. No, I never claimed it. In fact, if people go back to 2005, when I started having radio interview, the one thing I always stress, please do not confuse me for an MD. I am not an MD. I'm a scientist. I'm a physicist. I am not an MD. An MD could not have done this because they have their mind, they have blinders. Their mind is padded with certain training and how to write prescription and nothing else. But anyway, going back, when I realized that things that have been said during deposition were leaked on the web, proved two things. The dishonesty of the plaintiff attorney, and he's working with these trolls trying to discredit the company in the public eye, taking advantage of the court case. That's illegal. So I contacted my attorney and I asked him, okay, we had other evidence, but this is undeniable evidence. Because if you go in the listing of the state, there is no indication that our doctor is under investigation. There is nothing. His license is not restricted. There is nothing. So the only way they got it from is from the testimony. Okay, so go after him because he's violating the law. And my attorney refused it. No, I can't do it. It's too difficult. So I fired him. And then I contacted the court and I said, this case is illegal because I'm out of the state. You have no jurisdiction over me. The attorney has not done his job. So he's been fired. The case is closed. I'm not coming to Arkansas for the trial. So the judge issued finally an answer to the summary judgment. Of course, like all legal documents go on and on and on and on discussing, usually except for one case that we'll discuss later, they go on and on issuing all sorts of comments, all sorts of things, just to use up paper, and to me they are responsible for unnecessarily killing too many trees, to have the paper to go on with their nonsense. But anyway, that's my personal opinion. It's a waste of good trees to produce all these worthless documents. But anyway, his answer is that although the defendants, which means represented by me, but means the corporations, and actually even the doctor that was included in the lawsuit, and of course he was discharged easily, the defendants stated in their brief that they would supply deposition testimony for former LASE MED INC patient who has successfully received, they were success story for the leash therapy, okay? Supply deposition testimony. Okay, read what it says. No deposition have been filed, and no evidence exists to prove that leash therapy. Okay, I showed it, and I show it on the web that deposition were taken. So if they were not filed, that means that my attorney didn't do his job and cooperated with the opposition to eliminate undeniable evidence of what the effect of the leash therapy are. But he's saying, so he's either lying because the deposition were filed, or my attorney is lying, telling me that they were filed. In either case, he said, they don't know the position exists, therefore, we were essentially selling false hope, and therefore the motion for summary judgment is denied. Okay? Well, it's on the next page. Denied. Okay? Then we attack the idea of the fraud for the corporation, explain why this is ridiculous, and I already told you what the rules for fraud are. They should not have been in this lawsuit. And then it goes over the law, as usual, discussing all these things, and then you see what it says. Granted. So in part was granted, the fraud issue was granted, but no, the rest of the summary judgment, which is a bunch of malarkey again. But I wanted you to read the word granted because he took it back later in the final judgment. Okay? The federal judge said, we grant the fact that it's not fraud because you cannot prove that it was my intentional to hurt her. Okay? And then he took it back later with the phony trial. Okay, then even though I told him I wouldn't be there, and he actually, I think I have it here, even though even though I sent a letter stating, and that was dated April 7, or he received April 7. Even though that happened, he went ahead and actually issued a statement, which he should have, but it's rather obvious that unless the corporation provided an attorney, it will go into default. Because that's the law, and I had 30 days. So by May 7, I would have, which is the law, by May 7 I had to provide an attorney. And I believe I had the letter stating that, but who knows? In all this paper, I'm not sure that I can come up with it. Okay? Yes, there it is. Okay? Order. This is in answer to the fact that I fired my attorney. Then of course he had to, for some reason they claim he had to file a motion to withdraw. I fired him. That's pretty much black and white, and I told the judge that he was fired, so he has to issue a motion to withdraw. Ridiculous. But anyway, it's saying LASE MED INC and LASE MED INC of Arkansas, which by the way hadn't existed anymore, so what do you mean LASE MED INC of Arkansas, have 30 days to retain counsel. Failure to do so may result in a default judgment. It's not may, it's lying again. It's not may, it does. If you don't find an attorney for the corporation, it goes into default. And of course, when it goes into default, it will go in default for me also because I'm a part of the lawsuit and part of the corporation. So this whole thing was a complete farce and a complete violation of all the laws of this country. But anyway, then what happened? After I fired the attorney, I received a lawsuit. I was sued by my attorney because he wanted an additional $30,000 for doing nothing, not doing his duty. He didn't file the deposition. He wanted more money. And fire me, and he was suing me. So I turned around and I countersued. And because of his misbehavior, caused me to lose a lot of money. Refusal to do his job, to file complaint against the opposition that violated the law, or everything he did. And by the way, file also because the judge was not showing obvious sign of not being neutral, and he has to be by law. So I was asking him to do something. He didn't do it, and then he wanted more money from me, so I countersued him for failing to present to the file in the court the deposition. What happened? All of a sudden, he must have called because this was on a Friday, and that I received a lawsuit, and I filed the counter lawsuit. On a Monday, I received this thing that the attorney in Arkansas, the motion in support of a brief in support of motion to exclude testimony of, and these are the 4 names, okay, of this 4 patients. Exclude the testimony, like the deposition had been filed. So it was all intended to protect my attorney that had cooperated with them and failed to do the job. And this proves it, because before they said, even the judge said they didn't exist. Now all of a sudden they exist, but they need to be excluded. Okay? And why? Okay, we're gonna have fun with this one. Okay. None of the witnesses have any proof or their condition or treatment was similar to the one enough to Westphal to make them relevant. Even ask one of the patients, what treatment did you have? What makes you think that it was the same that Westphal received? And she said, Dr. Carpenter only offered one type of treatment, one kind of treatment, that's all. So, but he decided to ignore. And none of the witnesses will make any fact that it is of consequence. What their statement are of no consequence. That's what he's saying here. They have no value. That's his opinion. Okay? That's what he's saying. The testimony professed by the defendant in this is substantially outweighed by the danger of unfair prejudice, confusion of the issue, misleading the jury, or by consideration of undue delay, waste time, and needless presentation of cumulative evidence. That means has no value, should not be offered, the jury should not allow to hear. Also, substantial confusion and misleading the jury could occur. Substantial confusion and misleading of the jury could occur if the jury heard both sides of a story. I believe that's the reason why we have a jury system, because they have to hear both sides. And they say, substantial confusion and misleading of the jury could occur. None of the testimony offered show that the treatment received of the cancer treatment was similar to Therese Westphal. Okay, and he said without testimony showing that the treatment was similar, serious confusions arise whether the treatment is the same. It's advertising on the web that I only offer one type of treatment. And then he goes into more, this is the first part. Then it says the testimony, each one, okay? The testimony of all these witnesses, the entirety of all for the position expert offers by defendant should be excluded from evidence at the trial of this case. The testimony is irrelevant. See, people are telling you, I went for the least treatment and I am doing great. It's irrelevant. Contain a substantial hearsay. Gee, isn't it the testimony presenting the opinion of people? And if not irrelevant, is slightly prejudicial. All four individuals are essentially saying that they are somewhat satisfied. No, they're not saying they're somewhat satisfied. They all said, I'm doing great, I'm alive and well. But anyway, he said somewhat satisfied. Okay? And then he's gonna go to the deposition one by one. This patient deposition is inadmissible because it's irrelevant. She's telling you, this is 80-year-old. She's saying, I'm doing fine, it's irrelevant. It's irrelevant. The unfair prejudice outweighs the probative value of the testimony. The unfair prejudice is that she said she has no trust in standard treatment, chemo, radiation, and surgery. That's extreme prejudice. Was 80 at the time she was treated and claimed to have stage 3 cancer at the time of treatment. She has no knowledge as to whether she received the same treatment or Westphal. That's a lie because she said that she's the one who said I only offer one type of treatment. Then the next one, exclusion. This lady has never seen, and she's one of the patient that was a guest in our show and discussed her condition. Has not seen an oncologist concerning the alleged breast cancer. Well, you can see the pictures of her on the web, the alleged breast cancer, for 4 years prior to a treatment to Dr. Carpenter. Okay? Well, to Carpenter. Hey, heaven forbid that they could call me doctor, okay? Okay. Miss was not treated at the same facility of Therese Westphal. It was not treated at the same facility. While it's undisputed that Therese Westphal was treated at the Jacksonville facility. Was treated in North Little Rock. So Jacksonville, not Florida, Jacksonville, Arkansas, which is immediately north of North Little Rock. Okay. Westphal was treated in the office we had in Jacksonville, and then it became too small. We moved to North Little Rock, but because was treated in North Little Rock, and then it's not the same thing. And she also has limited knowledge of what treatment was done for her. She has limited knowledge of what treatment was done for her. And she does not have a prognosis. The purpose the deposition could offer the defense or a jury is that felt good about her treatment. No. There are pictures of her showing the healing. Of course she felt good, but there are healed tissue. Okay? So the deposition is irrelevant. And if it's not irrelevant, it's prejudicial. Okay? Then testimony is also irrelevant. If not irrelevant, it's prejudicial. Because Miss has no knowledge of what stage of cancer she was at the time she visited, of course, not Dr. Carpenter, of course not. Okay? She believes that the treatment was a prototype laser. This is contrary to Carpenter testimony concerning her treatment at Westphal. Huh? Oh, and Miss, by the way, that is Dr. And there again, even her, they don't recognize the fact that she's a doctor. She claims to be a podiatrist. She claims to be. And gives opinion testimony also, even though we know nothing of her qualification. She was not revealed as an expert and provided no expert report. Much of the testimony she gives in attend to use her alleged medical background to support treatment she has received on LASE MED INC. Okay, so basically, well, it's irrelevant. She didn't show her qualification. The deposition is under oath. People go under oath and they talk about their condition. They are not, the people that do deposition are not providing documents. And the witness they use, the Bebeka case, did Bebeka provide a document? No, except that his wife died. But how did he die? No evidence, no discussion, as we went over already, about no discussion of the other type of cancer that she had that we didn't treat. Okay, so that is fine, but the witness for LASE MED INC have no qualification. They are only claiming. They're saying it on their oath. No, it's just a claim. And then we get to she was never officially diagnosed with cancer. Wrong. She was. And they're lying. Yes, she didn't bring a diagnosis in court because the witnesses that give a deposition are not required to bring that. It's only the plaintiff with her claim. Okay, but then she said, and besides, Miss did not have breast cancer. She was never treated for breast cancer. She was treated in North Little Rock, Arkansas, not Jacksonville, like Westphal. And she's unclear what type of laser machine was used. The patient do not need to know what type of laser machine. That is the rule of FDA. They're talking about LASIK, but when they are using laser, the doctor is not obliged to give them detail of the laser. Only what the treatment does. That's the law of FDA. Okay, and then the testimony is irrelevant. There have been no medical report, there are no reports. Neither are their witnesses, but that is a different story. Those are acceptable, or ours are not. And then the testimony is irrelevant. If it's not relevant, it's highly prejudicial. These are people that refuse to receive the garbage standard treatment, and so they're prejudicial. This is the document. And of course, we expect that the judge would accept that. Okay. This is a note. This is the day that, well, I have to show you. It's connected with this, but I have to show you the statement that says where the trial will be. Even though I stated I would not be there, the LASE MED INC did not file an attorney in time. He wasn't going to file it, and May 7 it passed. Look, order. Jury trial scheduled for June 13, 2011. And the clerk is provided, is instructed to provide information for this. The trial is scheduled when there is no attorney for the corporation, and I said I wouldn't be there, okay? So that, by law, the May 7th date is passed, by law will go into default. That is the Code of Civil Procedure. And as I said many times before, the 14th Amendment and the Bill of Rights protect citizens from abuses that were happening in over the centuries in Europe, and they wanted these same things not to happen in the U.S., and states that every citizen is entitled to a fair trial. And the fair trial includes a neutral judge, which obviously I didn't have. The corporation did not have also. We didn't have a neutral judge. Not only that, it requires that the Code of Civil Procedure be followed. And the Code of Civil Procedure states that in absence of defendant, the trial cannot go on and the judgment will go in default. But the request in the original filing, the default is $75,000 are only mentioned. And the only thing that is mentioned is and fair fees, legal fees. A far cry from what came out. So June 13 was scheduled. And get this, the same day of the trial, there is the decision of the judge. There is no PDF document associated, but there is no PDF document associated with this. Because they didn't want to order granting plaintiff motion to exclude testimony and granted and for the reasons stated on the record at the pre-trial hearing. Basically, whatever the plaintiff attorney said, this is the reason why we are granting the request. He's not even explaining, he's just saying for what the attorney filed in pre-trial motion, what he filed is granted. So no deposition are allowed. The witnesses for the defense are not allowed. Then they have a trial, which is illegal, with choice of jury only picked by the plaintiff attorney. Other violation of the laws of this country. And if that were not enough, still not feeling too sure about the jury, how the jury would react, even a jury in a kangaroo court, totally controlled by the plaintiff attorney, even then they didn't feel sure enough to present the evidence in the deposition. That was not allowed. Then what happened? Of course, we have the judgment. Hey, great. So, and they have the witnesses of the plaintiff. They have the plaintiff, of course, you know, crying about her condition. The expert witness who is somebody that could not. And by the way, there was another motion, I don't know, I must have it somewhere, but anyway, it was another motion. Basically what was requesting is I could not appear as expert witness as my technology. I, who developed the technology, could not discuss the technology and be an expert witness on the technology that other people are copying me, but that I haven't fully figured out how to do it. So I knew already that whatever the plaintiff attorney requested, the judge, sure, whatever he says, granted. So they go ahead and do this illegal trial, and not feeling strongly enough about the jury that he selected, he made sure that no good depositions are there, only the oncologist that knew nothing of our technology. And then, oh, my wife died and she went there for breast cancer. No mention of the thyroid cancer that we didn't treat. That is, no matter how you look at it, that is perjury. No matter how you look at it. And by the way, the perjury holds that's a prison sentence, not what they claim to be fraud, okay? And the Attorney General handling of cases of fraud. By the way, the judge took it back and said that it was fraud. But anyway, so the award is $1 million for LASE MED INC, $1 million out of me, and $500,000 of compensatory damages. The $1 million are punitive. The patient paid $6,250 to have her cancer killed, because that's what the record said, her medical record, and you see it in the part of the medical record. She had paid only that money, but it's punitive. I guess it is punitive to make somebody well. She went and she survived all the, didn't give her as much chemo as they usually give to patients, but she survived that because she's a huge woman, really strong. The other one, the husband was crying about the fact that she died after a year of chemo radiation, aggressive chemo, aggressive radiation, which of course caused the other cancer, uterine cancer and other things she developed, plus the fact that she had an untreated thyroid cancer, so. But that was our fault. And that's because he said that, not because he provided any evidence of when she had chemo, when she had radiation. And by the way, she was sent home because they considered her hopeless, and she was sent home with hospice care. And you know what hospice care is? They call it euthanasia, I call it murder, because it's maybe she didn't have all of those. She just was having a tremendous reaction. She was a small woman with poor health because she had 6 kids in 8 years, so extremely poor health, no resistance to that type. But that was a good testimony, even if he provided no evidence other than his word. But no evidence, but my patient not only stating what their condition was, you could see them how healthy they were. So, it's ridiculous. It's a farce, but still. And then, of course, the attorney for the plaintiff came out of court and the press was there, and he had this attitude of arrogant and really malicious attitude by saying, oh, we won the case. What case? There was no opposition. That's not very difficult. It's a given to win a case when that's why they don't exist in this country. That's why this type of case is only offered in dictatorship and in Bolshevik Russia. That's why. I mean, the U.S. has always attacked Russia for trying dissidents and having a one-sided trial with no real deposition from the side, from the defense, only attacking them and then send them to Siberia because they were dissident. Well, how different is this? I'm a dissident to the AMA. I'm a dissident to standard cancer treatment. Not only that, I showed you evidence of the results of what I do. No, I had to gag. I could not speak the truth. I cannot provide my evidence. I could not discuss the technology, which is easy. It's basic science. It's not quantum physics, okay? It's not really anything that difficult to understand. It's basic little physics, simple, everyday life physics, okay? I call it little physics because when I was in Italy at the university, we had the little physics lab and we had to do all this testing, which we consider pretty simple. We're not really, but we consider it simple, and we call that class little physics. That's why I'm saying the simpler part of physics that don't require an enormous amount of mathematical knowledge to explain the theory and to confirm it, then it's called little physics. And this is little physics because you see it every day. Heat kills tissue, can kill a person too if exposed for long enough time. So, but this is not extreme. It's not extreme heat. People die if they stay in a car without air conditioning for 20 minutes. The whole person died, not the cancer or a tissue, just the whole person, the brain fried. But it's not a death by burning. It's not extreme heat. It's enough heat to kill the cell, and so you don't function anymore. But it's not something you can have a heart attack to. It's not something that will fall into the category of extreme. Extreme for the cells, not something that will burn. Anyway, so this was the outcome of this ridiculous trial. So the triumphant snake attorney came out and said, oh, we won because she didn't come because she didn't have any defense. Well, you took it away. I had plenty of evidence. I had plenty of defense. You made sure that you having the judge on your side, you took it away. That's what happened. Gagging order, I cannot talk, and my witnesses cannot talk. Well, pretty easy to have no defense that way. And then he said, well, we know we cannot collect because that outrageous amount of money, not to mention out of jurisdiction. We know we cannot collect, but this was done so people will read this, and women that are considering going to LASE MED INC for treatment will not go because this is bad for them, and because we say so, and because the AMA says so, okay? Don't go there, but we know we cannot collect. Then what happened? The first video of the truth rises to the top. We presented hard evidence of the fact that these people were not in the condition they said they were. And that outraged them. What could they do? They had to stop me because I had to be silenced all the time. I cannot be allowed to talk. So what they do, they file in Oklahoma federal court a motion to collect on the $2.5 million. Well, $1.5 million are to the corporation. You cannot collect it in Oklahoma because it's a Nevada corporation. You will have to bring it to the Nevada court, but it's a judgment in Arkansas, it has no jurisdiction in Nevada, and for that matter, not even in Oklahoma. So it was only left me. And then when the troll came out and said, "Oh, watch your back, he's coming," she knew, because this happened. The Truth Rises to the Top came on YouTube 3 days later. I didn't receive it till later, but the request to the court in Oklahoma was filed to collect on the judgment. Okay? So, and then of course there was an investigation trying to find out where all my property was. I don't have any, but so can't get blood out of a stone. And that's what it is, blood. But couldn't find anything, but the reality is that the court has no jurisdiction over the corporation or me. So that really went nowhere, but of course, you know, silence on that subject. And they said, "We don't know yet." I am pretty sure they know, but if they didn't before a couple of weeks ago, they know now. And that is just as bad. It's pushed under the rug. How Oklahoma is, I mean, attorneys are what they are. But I guess the judges do not get to that extreme as they do in Arkansas. In Arkansas is KKK territory, good old boys, so they can do anything they want to and get away with it. Okay? That's how they get a trial that violates, and this is a federal judge in a trial that violates the Constitution. So I think you have enough evidence now of what really went on, and when the trolls say, "Oh, there was a judgment against her," I think you have enough evidence to see what really happened. And that's what I wanted to expose, since I couldn't do it in court.